Trump warrant judge rejects the DOJ's attempt to seal the FBI affidavit, ordering redactions due shortly. We're going to go through the order that came out on August 22nd. We're also going to take a look at the Gang of Eight. You know these people, Intelligence Committee, so-called Congresspeople, who serve on all of the subcommittees, and they're supposed to guide America through trying times. They want access to the affidavit. And then we'll take a look at both dockets, the search warrant docket and Trump suing the government to appoint a special master. But before we jump into anything, we want to start here. This is Judge Reinhart's orders on the motion to unseal. And this is the battle, the culmination of the battle that has been taking place for some time here. Remember, Merrick Garland came out and he said that they were going to unseal portions of the search warrant. It was really only the cover sheet and the inventory list. Trump came out and said, release everything. And then the DOJ returned and they said, actually, we don't want to unseal the affidavit because of a couple things. One, it's going to be problematic for our investigation. Other presidents that we're incriminating, might know what we're doing. And they didn't want people to get more details about who was leaking to the DOJ and who was involved. And so they responded and they filed a motion opposing the unsealing. And last week we had oral arguments with Judicial Watch and a bunch of other media companies, ABC, New York Times, Washington Post. They were all skidding in there to try to get the court to unseal these records. And the judge came out with a very interesting ruling. He said, well, he sort of hemmed and hawed. He kind of kicked the can down the road and didn't give us many answers. But today or yesterday at the close of the day, he did. He said on August 22nd in a 13-page order, here's what I'm actually ruling, right? And we cut this last time. We said, I don't know if he's going to unseal this whole thing or not, because he said at present was the language he used. He says, at present, I'm not convinced either way. The government hasn't met their burden, but they haven't not met their burden. And so some people were saying, oh, he's going to release it. And I said, hold on a minute. He's saying at present, and it was kind of a weak kick the can down the road argument. Yesterday on August 22nd, he did come out and clarify all of this for us. So here are his orders now on this. He says, all right, on August 8th, the government raided Trump's home. Presidents are a private club that is also a part-time resident of Donald Trump. He said a lot of people were crashing in here to go and unseal this affidavit so that they could see it. Specifically, Judicial Watch came in hot, Albany Times, New York Times, NBC, Cable News Network, CNN. We've got WAPO, EW Scripps, Miami Herald, Time, Dow Jones, everybody. They all asked for the unsealing of the affidavit. But they write, the judge says, the government opposes the request to unseal. Okay, so media wants it open. Government wants it closed. This order is memorializing and supplementing my rulings from the bench hearing that took place back on August 18th, because it was kind of a mess. We didn't know what was going on. He says, the judge, neither former President Trump nor anyone else purporting to be the owner of the premises of Mar-a-Lago has filed a pleading taking a position in any of this stuff. Trump lawyers haven't taken a side. Nobody who is a part of Mar-a-Lago has filed anything. So the judge says, let's just get that out of the way and clear this up. Judge Reinhart writes, on August 5th, 2022, the court issued a search warrant for the premises after finding probable cause that evidence of multiple federal crimes would be found at the premises. This judge signed off on that warrant. An FBI special agent's sworn affidavit provided the facts to support the probable cause finding, right? That's the written document. The government submitted 1, a criminal cover sheet, 2, an application for a warrant, 3, an affidavit, 4, the proposed warrant, and then 5, a motion to seal along with an order to seal, all as part of this warrant package. Now, the government asserted there was a good cause for sealing the entire warrant package. They said public disclosure might lead to the investigation being compromised or evidence being destroyed. And that's all pretty usual. The motion to seal the entire warrant package was granted, and after the search on August 8th, the government filed an inventory of the seized items as required by code. Go raid the property, let us know what you find, make sure you file the inventory so that if there's any objections or issues with what you stole or took, then we can contest that, okay? They did it. Beginning on August 10th, interveners, so those are all the media companies, filed motions and they wanted to unseal the entire package. On August 11th, the government moved to unseal the warrant and a copy of the inventory that had been redacted only to remove the names of the FBI agents. Court granted the motion to unseal and they are now publicly available. And so they say those motions are moot. We don't have to argue about those. Okay, we got the cover sheet. So the judge is dividing the warrant package up by numbers. Okay, 1 was the cover sheet, 2 was this, and 3 was, okay, 1 and 2, done. Don't need to argue about those. But what about the rest of the package? Says on August 12th, 2022, the government filed under seal redacted copies of several other documents from the warrant package. And we haven't seen these because they're all under seal. The criminal cover sheet, the warrant by telephone, and other documents. They were also redacted to conceal the identities of the U.S. prosecutors, the U.S. attorneys, as well as the FBI special agents. And the government does not oppose unsealing those. Interveners do not object to the limited redaction. So they said, okay, look, we'll unseal some of those, but we also want their redactions of their names. Are you cool with that? No problem. Yes, sounds good. Judge says, I find that the redactions are appropriate. Yeah, I protect the identity and the personal safety of both the prosecutor and the investigator. So we'll do that. And so we're granting those motions as well. Okay, so some new motions will be unredacted or unsealed. So the judge is clearing out the rest of the warrant package, right? So basically we need to see the affidavit. It's all that's left. It says, okay, all that remains then is to decide whether the affidavit should be unsealed in whole or in part. And we didn't have a lot of debate over this or a lot of answers about this during the last proceeding. It says, with one notable exception that is not dispositive, which is dispositive meaning it doesn't decide the entirety of the issue. The parties agree about the legal principles that apply. As discussed below, the parties disagree about whether there's a First Amendment right to public access of these documents. They disagree only about how I should apply those principles to the facts here. So they both say, okay, it's First Amendment, and we just don't know how it should be applied here. The government concedes that it bears the burden of justifying why the affidavit should remain sealed. We have a presumption of public access, that we have a right to see this stuff. So why are they wanting it sealed? They've got to make the justification. So the judge laid all that out as foundation and then gets into the meat and potatoes. He says, look, we've got some pretty applicable legal principles here in America. And he says it is a foundational principle of American law that judicial proceedings should be open to the public. Now, I could rant and rave about this point till the end of the earth. You know, every federal court proceeding is largely closed, but they start their sentences like this. Like you can't call in or they don't video broadcast anything. And including in this proceeding, this judge didn't allow you to call in for this last hearing. So he says, okay, it's a foundational principle that judicial proceedings should be open to the public, as he has one of the most closed courtrooms in America. All right. An individual's right to access judicial records may arise from the common law, the First Amendment, or both. And he gives us some case law. He says, where a sufficient reason exists, a court filing can be sealed from the public view, but you got to have a good reason for it. And he gives us some case law, this case out of the 11th Circuit, 2007. They talk about how you decide whether there is good cause. What are the elements, the indicia that the government can proffer to justify sealing documents? Well, here's a couple of them. Courts can consider, among other factors, the following: whether access would impair court functions, right? So put a 1 there. Or harm privacy interests. That's another factor, number 2. Likelihood of injury, if it's made public. That's the 3rd variable. The reliability of the information, number 4. Opportunity to respond, 5, information about public concerns, 6, and whether there's the availability of a less onerous alternative, number 7, right? And so you've got, 7 different balancing factors. That's a lot of them. You got to weigh all of these out and say, well, does Trump have legitimate privacy interest in some of this stuff getting out? Well, yeah, he does, of course. But does the government have privacy interest in their investigations? Yeah, I guess they do. So we got to balance them out. And the judge is going to do that for us right now. He says, look, they also consider whether records are sought for such illegitimate purposes like promoting public scandal or unfair commercial advantage, or whether they're going to promote public understanding of historically significant events and all sorts of other stuff. Very important that we get access. But the judge says, despite the First Amendment right of access, a document can be sealed if there is a compelling government interest and denial is narrowly tailored to serve that interest. You got to match them up together. Why do you want this thing sealed? And can we do that in a way that is extremely narrowly tailored so that we don't have an overbroad prohibition that harms other legitimate public interests? Says the 11th Circuit, which they're in, has not resolved whether the First Amendment right of access applies to pre-indictment search warrant materials. So it hasn't been litigated yet in this court, which is kind of amazing, isn't it? I mean, we've been around for a while. It's kind of interesting to think about this, like new issues come up that have not been litigated. This is one of them. The government argues, quote, the better view is that no First Amendment right to access pre-indictment materials exists because there is no tradition of public access to ex parte warrant proceedings, meaning that if the prosecution just goes and gets a warrant outside of the sort of scope of the defense, they don't get to see it because the defense doesn't even get to see it. Why would the public? Nevertheless, the government says that I need not resolve this question because even under the First Amendment test, a compelling reason exists for continued sealing. The judge says, I do not need to resolve whether the First Amendment right of access applies here. Not even going to consider it. He says, as a practical matter, the analysis under the common law and the First Amendment are basically the same. He says, one, we look at the party, whether they're sealing it and whether they have a sufficiently important interest in secrecy that outweighs the public. So more interest in secrecy here than public knowledge or vice versa. And two, whether there is a less onerous or, said differently, a more narrowly tailored alternative to sealing. Like, do we have to seal it? Can we just redact it? Here, the judge says, as I found and I discussed below, both tests lead to the same conclusion. And so we'll fly through the discussion, but it says, look, we got to balance the parties' interests here. The government argues that unsealing the affidavit would jeopardize the integrity of its investigation. The government says, as the court is aware from its review of the affidavit, it contains, among other critically important and detailed investigative facts, highly sensitive information about witnesses, including witnesses interviewed by the government and specific techniques. All of that needs to be kept under seal to protect the integrity and the secrecy of our investigation. But the judge says, in the context of an ongoing criminal investigation, the legitimate government concerns that they have, they include the following: witnesses and their cooperation, law enforcement's ability to use certain investigative techniques, obstruction issues, and whether charges are brought at all, and reputational damage. Okay, so these are all the things that they can consider. And the judge says, as the government themselves aptly noted at the hearing that we already talked about, these concerns are not hypothetical in this case. One of the statutes for which I found probable cause was 18 U.S. Code 1519, which prohibits obstructing an investigation. Oh, you see that there. Judge took a look at this and he said, obstructing an investigation seems like it might fit. Also, as some of the media interveners have reported, there have been increased threats against the FBI. And he cites a bunch of articles from that. Cincinnati man in Ohio, and so on. A lot of articles. After the public release of an unredacted copy of the inventory, FBI agents were harassed, and he cites a Business Insider article. Given the public notoriety and controversy about this search, it is likely that even witnesses who are not expressly named in the affidavit would be broadly identified over social media and could be harassed and intimidated. And he says, all right, look. Balancing all of these interests together, balancing the government's asserted compelling need for sealing against the public's interest in disclosure, I give great weight to the following factors. 1, there is significant likelihood that unsealing the affidavit would harm legitimate privacy interests by directly disclosing the identity of the affiant, which is the FBI agent, as well as providing evidence that could be used to identify witnesses. As discussed above, these disclosures could impede investigations. And he says this factor weighs in favor of sealing. Okay, he's going to go through all of them and just put one on each side. The affidavit discloses the sources and the methods used. I agree with the government that it does contain critically important information. This factor weighs in favor of sealing. The affidavit discusses physical aspects of the premises, which is the location protected by the Secret Service. Disclosure of those details could affect the Secret Service's ability to carry out their protective function, and so that factor weighs in favor of sealing. And as the government concedes, this warrant involves matters of significant public concern. And so certainly unsealing the affidavit would promote the public understanding of historically significant events, and this factor favors in favor of disclosure. So balancing them all out. So far, if you're keeping count at home, it looks like it's 3 for sealing and 1 for disclosure. So it's not looking too good here. Now, the media and the interveners, they're emphasizing the court is required to consider if the press has already been permitted substantial access to the contents of the records, right? And the DOJ has been leaking like a sieve. They've been leaking out, nuclear codes. And today was a new one, 300 documents. And so they go from letting you fill in the gaps with your imagination to then filling it in with nuclear codes to then going from a nuclear code threat to a more a volume type of a threat. It's the 300 overdue library books. But if they're leaking all of this out to everybody, if they're telling us that this was a letter about Kim Jong-il or this was a letter from Barack Obama or whatever, well, the media already knows what's in the records. And so sealing the records just to keep them sealed when we already know what's in them, it's like, hello, you're not bluffing. We can see your cards, dummies. Just show them already. We can already see them. The government acknowledged that the unsealed warrant and inventory already disclosed the potential criminal statutes at issue here. And we've got that. One intervener argues that there is no privacy interest because Trump and his counsel have spoken repeatedly about the government's search and publicly disclosed information about the subject of the search. Another intervener is saying all of this is already public. A third says the investigation has been made public by the target of the warrant himself. Everybody is demanding openness. Members of Congress have demanded the Justice Department provide an explanation. In short, with so much publicity surrounding this, the court should be skeptical about the government claims that this is going to invade privacy. So the judge is going through all of the interveners and just sort of cataloging their objections to continuing to keep it sealed. So the judge says, look, no one disputes that there is a lot of public discourse about this warrant, okay? I signed it. Says, nevertheless, much of the information being discussed is based on anonymous sources, speculation, or hearsay. The government has not confirmed its accuracy. No, they just leak it to the New York Times. In any event, these arguments ignore the contents of the affidavit identify not just the facts known to the government, but the sources and methods used to gather those facts, like what witnesses were involved and what type of investigative techniques they used. That information is not known to the public, and for the reasons discussed above, the government has a compelling reason not to publicize that information at this time. Judge writes, I do not give much weight to the remaining factors relevant to whether the common law right of access requires the unsealing. Allowing access to the unredacted affidavit would not impair court functions. Doesn't impact us. Having carefully reviewed the affidavit before signing the warrant, I was and am satisfied that the facts sworn by the affiant are reliable. Saying, I think that FBI agent, he's pretty on the money. So releasing the affidavit to the public would not cause false information to be disseminated. So that sort of goes in favor of unsealing it. He also says there is no indication here that the media seek these records for any illegitimate purpose. They all want it for good reason. So the judge says, gosh, he's stroking his chin. He says, after weighing all the relevant factors, I find that the government has met its burden of showing good cause / a compelling interest that overrides any public interest in unsealing the full contents of the affidavit. So the judge ruling that the full thing is not going to be unsealed. Government has met its burden, but says, I still have one more thing to consider. Remember in there about that less onerous alternative? Is there any more narrowly tailored opportunity here? The government argues that redacting the affidavit and unsealing it in part is not a viable option because the necessary redactions would be so extensive as to make the whole thing meaningless. It would just be a big blanked out document. Judge says, but I cannot say at this point that partial redactions will actually do that, he says. I may ultimately reach that conclusion after hearing further from the government, but I can't say at this point, okay, this is hedging words, just like he said last time, at present. I cannot say at this point that partial redactions will be so extensive that they will result in a meaningless disclosure, but maybe. And this is honestly what he did last time. He sort of said, I can't imagine me sealing the entire affidavit. And then he came out today and he said, I am basically sealing the entire affidavit unless you can show me redactions, and I am open to having redactions, submitting some of them, but not all of them, right? So he's still not real sure. He says the government argues that even requiring it to redact portions of the affidavit that could not reveal agent identities or sources or methods imposes an undue burden on its resources and sets a precedent that could be disruptive and burdensome in future cases, future presidential raids. Says, this is the judge, I do not need to reach the question of whether in some cases these concerns could justify denying public access. They very well might, particularly given the intense public and historical interest in an unprecedented search. You see that? Of a former president's residence. The judge himself says, unprecedented search. The government has not yet shown that these administrative concerns are sufficient to justify sealing. So he's coming at it from both angles. The government, he writes up here, has met its burden that the entire affidavit will not be unsealed. But then he says down here, also not enough to justify total sealing. So he says, finally, I therefore reject the government's argument that the present record justifies keeping the entire affidavit under seal. In its response, the government asked that I give it an opportunity to propose those redactions if I decline to seal the entire affidavit. I granted that request, and I gave the government a deadline on noon this Thursday, August 25th, which of course we will be covering. Make sure you're subscribed so that you don't miss it. Accordingly, it is hereby ordered that by that deadline, the government shall file under seal a submission addressing possible redactions and providing any additional evidence or legal argument that the government believes relevant to the pending motions to unseal. Done and ordered in chambers, August 22nd, signed by Bruce Reinhart, United States Magistrate Judge. So, a big motion with a lot of meat there. The judge calling this unprecedented, saying that this has never happened before, raiding and searching a former president's residence, but still not too sure about redactions and whether or not we're going to see full redactions or not. Now, the Gang of Eight, a bunch of Republicans who are on these so-called intelligence committees in our United States Congress, they want access to the Mar-a-Lago documents. And you can see these two yahoos here, Mitch McConnell and Chuck Schumer. They want to see it. They sent a request over calling it the latest sign Congress is trying to get some insight into what is going on here. A group of congressional leaders charged with reviewing the most sensitive information has asked the Biden administration for access to the documents that were seized. Two people with direct knowledge of the request told Politico. And I think that probably comes from the Gang of Eight, right? Knowledge of the request comes from them. The inquiry from the so-called Gang of Eight comes as lawmakers from both sides want to know about the unprecedented investigation into the former president. Similar requests coming from other people: Mark Warner, Virginia, Vice Chair Marco Rubio, Florida. They're asking for the affidavit. It includes, let's see who's on this list: Chuck Schumer, Mitch McConnell, Nancy Pelosi, and House Minority Leader Kevin McCarthy all want access to the affidavit. We'll see if the Biden administration gives it to them. But those are the docket updates in both Trump and the Trump versus United States docket. Looks like this. Not a lot of activity here today. He filed a lawsuit, sort of a demand for the appointment of a special master. And we saw a little bit of activity here today. The judge is saying you have to refile your notices or motions to appear pro hoc vice to some of Trump's lawyers. So sort of a refiling is needed. We have on August 23rd, the judge is also asking Trump's lawyers to determine or to file a supplemental motion about why they think this court can grant them a remedy. See this here? They say, Trump, you and your team, you have to tell us what your asserted basis is for this court's jurisdiction, whether it's legal, equitable, anomalous, or both, whether you're bringing this as a legal cause of action or an equitable cause of action. They are different. The framework applicable to exercise our jurisdiction, and the relief that you want, including an injunctive relief pending resolution of the motion, right? So sort of what specific order do you want? The judge is saying we need more details. And then I want to know about service, and that's it, right? So not a huge update there on the Trump docket there, but that is the major update. Trump judge rejecting the sealing of the entire affidavit, but very likely going to be considering some pretty hefty redactions. We'll have to wait on Thursday to see what those look like, and we'll of course be covering that. I hope you do join us by subscribing and liking this video so that, the algorithm knows that we're here.